Hello friends, today I'm going to discuss an important right concerning the bail. As we know that the jail is exception and bail is rule, and provision concerning the bail has been elaborately given in section 437, 438, 439 of CrPC. But the point arises, whenever we are requiring in a case and due to fault of the police the warrant or someone has not been served, the initial warrants, and later on it got converted to a non-bailable or a standing warrant, then whether we are entitled to get the bail or not, just due to the negligence of the concerned police, the chronic warrant has been issued against us. So on this chilling topic, the Honorable Supreme Court has given the recent guidelines. So in this video, I will discuss the guidelines along with your rights, the duty of police, and apart from that, I will provide you solution. In such cases, what you could do and what is your right under the law. So topic is quite important. Whatever I'm going to narrate to you, please note down the same so that if you're having the same issue, you could deal with easily. So let's move on the screen. So friend, it's a very recent topic and judgment by the Honorable Supreme Court, which is passed in special leave petition 8247/2023. Actually, in every case where your rights are going to be affected and you move to the Honorable Supreme Court, it is a special leave petition. Whenever it is going to be admitted, it is called leave granted, and finally it has been converted into a criminal appeal, and matter is ultimately heard as a criminal appeal if matter pertains to the criminal jurisdiction of the Honorable Supreme Court. In this case at hand, the accused was behind the bar for the period of nearby 1 year 4 months. In the matter, charge sheet has been filed, and the application of the petition is opposed on the ground that the petition did not appear before the concerned trial court. Means the prosecution is trying to convince the court that he is not cooperating with the trial proceeding, and that's why the warrant came to be issued, and finally he has been confined. The court submitted that the accused, if is in prison in another case, it is a duty of the concerned police to produce him before the concerned trial court. The petitioner cannot be blamed for the negligence on the behalf of the police authority. So it is quite clear that it's a duty of the concerned police to produce you as per the norms of CrPC, and it is a duty that has been imposed on the police as well. You could read CrPC in that connection. And apart from that, if you are not produced, your right to bail could not be affected merely on the ground that the police is negligent. The court submitted that if such negligence has been happened, the rights of the accused is going to be happened, and in that scenario is entitled to get the bail. So the court ordered that the concerned accused is to be released on bail in connection with certain case pending at certain district regarding the satisfaction of the trial court proceeding. The court submitted that the bail is to be subject to the trial court satisfaction, but the key point is that the trial court could not act in the arbitrary manner. While enlarging the accused on the bail up to its satisfaction, it is duty bound to follow the norms provided by Honorable Allahabad High Court, because it is in the state of UP, and Honorable Supreme Court, so that the surety bond and the personal bond could be taken on record as per the norms of CrPC and the guidelines provided by Honorable Supreme Court and Allahabad High Court from time to time in their pronouncement. The court specified that the concerned petitioner will cooperate with the expedient disposal of the case, and ultimately the court disposed of the petition with the said direction. So friend, by the bare perusal of this guideline, we could draw the three conclusions. Number one, if you are behind the bar for a long time, it is a ground for bail. Filing of charge sheet is additional ground for bail, and if you are confined in another case and in a subsequent case your appearance could not be ensured, and ultimately chronic warrant like NBW or standing warrant has been issued due to the fault of police, because they are duty bound to produce you in that case. If they have not produced you, warrant has been issued, in that scenario you could not be faulted just due to their negligence, and you could easily move the bail. So it is quite clear that the right to get a bail is an absolute right. The right to get a bail is a fundamental right. Whenever such scenario occurs, you could easily move the bail application before the concerned trial court by relying on the said provision of law. So this is an important update for your rights. For such updates, please follow my page, subscribe my channel. See you in the next video. Till then, Jai Hind, Jai Bharat.